good question, and Ms. Pryor, this question will come to you first. How many employees are needed in the office of the Commonwealth Attorney?
Way more than what we have. Currently, I have on staff 3 full-time attorneys, 1 part-time attorney, a detective, a victim's advocate, and 2 secretaries. Just recently, we were able to obtain funding to hire an IT person to do computer work, and I just received word recently that we got another part-time prosecutor position granted to our office. So we're in the works of hiring that person, and every available resource that we can get, we utilize. So I'm fortunate to gain another person on the staff. I don't think that we could ever fully do our jobs without the positions that we have, and we could always use more.
Okay, thank you. And Mr. Bowling, same question. How many employees are needed in the office of the Commonwealth Attorney?
That's a good question, because you only get what Prosecutor's Advisory Council will give you. You can ask for all you want, but they're going to limit what you can get. When I was the Commonwealth Attorney, we had 2 full-time assistants and 1 part-time assistant. We handled approximately 800 cases, which is about what they handle today. What I would like to see is more administrative positions. There's a lot of discovery that is handled, preparation of CDs, DVDs, things of that nature, that are more appropriately handled by someone who is trained administratively versus having a Commonwealth detective do that kind of work. So what I would look to see is trying to get more administrative assistance in there, because I think as far as prosecutor-wise, I think there's sufficient numbers there based on the caseload, but definitely need help administratively.
All right, and Ms. Pryor would like to rebut, so 30-second rebuttal, Ms. Pryor.
I was just going to agree that yes, we are only allotted a certain number of positions. I have been able to obtain a couple more positions since I have taken office in 2007. What I'm working on right now is trying to obtain some funding for an additional victim's advocate, at least part-time, because I know that there have been some increases in victim-related laws, and I believe that it could only enforce our communications and our relationships with the victims of crime to have an additional person in that role.
Okay. And you'd like a 30-second response?
It'll be fine. I think you have 1 victim advocate. She does a great job, and I think she does a great job. So there's no reason that she doesn't really need any help. She can handle it. They need more help otherwise administratively. When you get someone else doing administrative, that potentially could free her up some of the things that she's doing.
Okay, thank you. Let's change gears a little bit here and move in a different direction with this next question. And this one will go first to Mr. Bowling. And this question is, do you have any suggestions on how the county might better address the opioid epidemic?
Best way for the county to address this current epidemic that we're going through, and I say current because when you deal with drugs, everything is an ebb and flow. We've got to get federal involvement. This is not something that the Commonwealth of Kentucky or Christian County can take care of. This has got to be something handled on a federal level, and we've got to work with federal law enforcement agencies. We've got to work with doctors. We've got to work with hospitals and pharmacies. It's got to be a united effort by all resources. And I'm proud to say, when I was Commonwealth Attorney, we had a very active working relationship with the FBI, DEA, with regard to drugs. So I anticipate that relationship will develop once again based on the fact that I've talked to them. If they're interested in coming here and working together and seeing what we can do.
Okay, thank you. And Ms. Pryor, same question. Do you have any suggestions on how the county might better address the opioid epidemic?
Yes, and as Mr. Rowling said, the federal authorities are very active in investigating and prosecuting criminals that are feeding people with these addictions. I've worked closely with our U.S. Attorney, with the ATF, DEA, and the FBI, and they are actually working on doing some roundups locally. But more than that, we have to educate our youth and we have to work with them to prevent them from becoming involved in this activity. I've been active with the Christian Convention Council in doing that, and we just received a grant this week to purchase over 500 packets that will chemically deactivate prescription medications. So when someone is no longer using their medication, they can deactivate them in an environmentally friendly way. So I'm looking forward to getting them out to all of the schools and all of the first responders here in the next week or so.
Okay, thank you. All right, so we're going to go to a new question. This will go to Ms. Pryor first. How do you determine which cases to take to trial and which cases to resolve by plea agreement?
Well, first of all, someone who is charged with a crime has a right to a jury trial. They also have a right to plead guilty. And if someone is guilty of a crime and they wish to plead guilty, then we typically allow that to happen as long as it's within the parameters that fit the crime that they're charged with, and as long as the victim is typically on board with that decision. In the event that we cannot reach an agreement, then we take those cases to trial. We don't cherry pick just the very best cases to take to trial to bump up our conviction rates. We take the cases to trial that need to go to trial to keep the violent and the persistent felons off of the streets. Sometimes that doesn't end in a win, but we do the best we can in presenting and preparing those cases for jury trial when we are placed in that position.
Okay, and Mr. Bowling, same question. How do you determine which cases to take to trial and which cases to resolve by plea agreement?
As a prosecutor, you make an offer to a criminal defendant, and whatever that offer is what you believe a fair resolution for those particular charges would be. The defendant has the right to accept that or reject it. If they reject it, they can make you a counteroffer of something less. You can think about it. If you think that's a fair and just resolution, then you can enter it. If you can't come to an agreement, then you take it to trial. I've never cherry-picked cases. I've never lost a murder case, and I've tried several of them. So I don't think I've ever cherry-picked.
Okay, we have a rebuttal. Okay, 30-second rebuttal, Ms. Pryor.
I would just say that as far as the cases that are chosen to go to trial, we don't necessarily choose which ones go to trial. If someone is charged with a felony, and Mr. Rowland knows this as well as I do, sometimes the evidence is not everything that we would hope it would be in going to trial. And sometimes we have to take that chance and roll the dice. We have won cases at trial on a lot less evidence than we have had in others that have been losses, and that's just something that comes with the territory.
Okay, thank you. And you have a response to that rebuttal. 30 seconds, please.
I've lost 7 trials. Out of 101 trials, I've lost 7. All 7 of those are my fault. Every one of them. Not because of a witness, not because of some officer, my fault. I'm the prosecutor. I said there's enough evidence to convict this person, therefore I indict them. If I lost the trial, I lost the trial. Period.
Okay, thank you. All right, we're going to move to a new question. Mr. Bowling, you will get this one first. What role should the victim play in the prosecution of his or her case?
The victim should have input into the case. The victim should have the right to explain everything that's happened in the case, how it's affected them, how it's affected their family, how it's affected relationships, how it's the total impact that this crime has had on them. They should have the ability to meet with the prosecutor and get that prosecutor to understand the effects that it's had on them. Hopefully, by understanding the effect, the prosecutor will then know the severity for which the prosecution should be sought as far as some kind of resolution. The victim should have the opportunity to know what the resolution is. They should have the opportunity to say whether or not they agree or disagree with that.
Okay, thank you. And Ms. Pryor, same question. What role should the victim play in the prosecution of his or her case?
I take great pride in the relationships that my office has with the victim in every single case that we have in our office. myself, my assistant Commonwealth attorneys, my victims advocate, and even other staff have contact with them regularly. We notify them of court dates. We talk with them about what they want to see as far as outcome goes. We find out what money might be owed to them in restitution. We meet with them when they come to court. We help them prepare for trials if that is the case, the way that we decide to move forward with the case. We take them to the court to let them sit in the courtroom and experience what a trial would be like. And we also take into account their feelings and whether or not they wish to proceed with a trial or whether they wish us to negotiate for a case.
Okay, thank you very much. No rebuttals. Cool, okay. The next question will go to Ms. Pryor first. What are the items or issues that you look for in choosing a jury?
Choosing a jury. I have a standard list of questions that I ask. Many times it is involves their prior service on juries, if they've ever been involved in a criminal jury trial before, if they've ever been a victim of a crime before, if they've ever had dealings with our office or with the particular law enforcement agency that we are working with. I ask them questions about whether or not they're able to put their sympathy aside and vote just on the facts and circumstances and evidence that's presented to them. I also try to make sure that they will not be influenced by what we call the CSI effect and expect evidence that we just simply are not able to produce to them.
All right, thank you. And Mr. Bowling, same question. What are the items or issues you look for in choosing a jury?
Well, they do 3 and 4 day symposiums on how to pick a juror, so I'm not going to go into all that. When you look for a juror, you're looking for somebody who is going to be impartial, somebody who's not going to let some experience in their life affect their ability to sit and weigh the evidence in this particular case. You're looking for that person that kind of really has no emotion. They're not really excited about something, but they're not really upset about something. You want just that calm person who's going to sit and listen and then sit with 11 other people and discuss what evidence was presented to them, and then as a group make a decision on a verdict. So that's kind of what I look for, is just that calm person and stuff.
All right, thank you. All right, new question. Mr. Bowling, you get this one first. In what kinds of cases or situations would you recommend probation as opposed to incarceration?
Under our current judicial system, the Commonwealth does not recommend probation in cases. With both of our circuit judges, your options are either to be neutral, which allows the decision to be up to the judge, or you oppose probation. So for that reason, that question really doesn't fit our system. But as far as cases that I think probation is appropriate, first-time offenders that are involved in some type of drug case where you're going to be going to some type of rehabilitation program, that's appropriate. A person who maybe has committed a theft, who's done some jail time prior to disposition of the sentence, or it could be, it could be just a low-level offense for the most part. But again, in our current system, both of our judges make the decision on probation.
All right, thank you. So I'm going to ask the question, Ms. Pryor, you may have to sort of extrapolate from that as well if it doesn't apply here. In what kinds of cases or situations would you recommend probation as opposed to incarceration?
Well, there are certainly cases in which probation is appropriate, and we also have what's called a pretrial diversion program for first-time Class D felony offenders, and we pretty regularly make offers with regard to those pretrial diversions. What that does is it allows those low-level offenders, the addicts that are stealing maybe to support their habits, to enter this diversion program, and if they are on probation for a certain period of time and have no violations, then they are able to eventually have their case dismissed. Now, the cases that we will absolutely not recommend probation for are violent offenses, sex offenses, repeat offenders, drug traffickers, child abusers, and cases such as that.
All right, thank you very much. And this is, the next question